All right, so I'd like to continue with the program now. The next session is very important, very interesting. It's called Working with Contingency Lawyers and Litigation Finance Companies. Speaking on this issue, we have two gentlemen that will speak to us. We have Michael O'Shea, founder of the O'Shea firm. Michael O'Shea is the founder of his firm, which specializes in patent monetization. The firm advises clients on a full contingency basis in litigating, licensing, and selling their patent portfolios. Before founding his firm, Michael O'Shea was a patent litigation partner in three major law firms. I've known Mike for more than 10 years, and I know what great work he does. I made some money from his efforts. He's tenacious, and really appreciate the work that he's done. We also have speaking with us today, Aaric Eisenstein, who is the founder and managing member of ASE Monetization. Aaric Eisenstein is the founder of his firm, where he helps companies unlock value from illiquid intellectual property. With over a decade of experience at personalized media communication, he focuses on the business of IP strategy, finance, and licensing. So very pleased to have both gentlemen speak to us. So Aaric, I'll turn it over to you.
Thanks. Appreciate the kind introduction. Nice to be here. So Mike and I are going to be talking about four basic areas: the current climate of what's going on, litigation financing options, how to work with your law firm, and how to work with litigation funders.
So I'll start off. Eric and I will be taking the lead on every other slide. So if you're keeping score at home, you'll know who's speaking depending on which slide we're on. First, with respect to the current climate, things have changed in the last 10 or 15 years. Back in the day, contingency counsel wasn't really that hard to find. There were plenty of lawyers who would take a case on contingency because the patent laws were so much stronger. However, in the last 10 or 15 years, the climate has changed quite a bit. And in fact, many law firms have lost cases. And when you lose a case, whether it's 101 or from the PTAB or for some other reason, the firm takes a big hit. And what has happened is firms have started to try to hedge a little bit. They will still take some full contingency cases, but it's really the exception, not the rule these days. If you have a spectacular case where the law firm says, we're either going to win a trial or we will get a good settlement, you won't have trouble finding a full contingency firm. Likewise, if you have a patent that is infringed by a lot of companies, where you can have a pretty strong sue and settle program, law firms will do that on contingency as well. But otherwise, if the case is good but not necessarily stellar, and if there aren't numerous defendants, a law firm will seek to hedge. They won't have the upside that they could, but they won't have the downside either. And a small litigation boutique might be a little more aggressive than, say, a larger firm with corporate and real estate departments. Those people will usually vote against contingency. So it's a different climate than it used to be. We've listed a few of the factors here. Everyone knows IPRs and 101. Just recently, in the last week or so, the Federal Circuit came down with an en banc decision, the Echo Factor versus Google case, where they have put even more stringent requirements on damages experts, generally for the patent owner. So it's a different climate. The Echo Factor case we haven't seen the ramifications yet, but I don't know that they're necessarily going to be that good for the patent owner. So it's a different world now. If you can find a good full contingency firm, I say take it. But by and large, you're going to have to deal with litigation funding. Eric?
All right. So as Mike mentioned, there really are kind of two outside or third-party funding options when you're looking to create an enforcement campaign. The first is you can work with a law firm that is going to advance all or cover all of its own fees. And I think it's important, sometimes people hear legal fees and they don't really understand exactly what entails there. So you've got fees, which is the amount of money that's actually paid to the law firm. That's their profit. That's the money that they make for doing the work. And then there are costs. And the costs are things, it could be expert witnesses, it could be travel, it could be depositions, all of those kinds of things. So when you're talking with your law firm and they say, well, we'll, take care of our own fees, but you've got to come up with costs, that can be a substantial, well into the seven figures. So it can be a substantial amount of money, and you're still going to be looking for a place to get that expense financed. So if you can find a law firm that takes care of both the fees and costs, frequently that's a good way to do things. You're going to be dealing with an overall lower cost of capital, typically, just because law firms structure their deals differently and generally don't have the same kind of multiple that a litigation funder would. And oftentimes law firms, even when they present themselves as being a full contingency firm with or without costs, actually have their own financing source operating in the background. So what they do is they enter into a portfolio kind of financing operation where typically they will have an insurance company and a lender that provides them, it can get a little bit complex, but effectively provides them financing for all of the cases or some large subset of the cases that they take in. So from the litigant standpoint, it looks like you're dealing with somebody that is able to provide all of the necessary financing, and they've got their own kind of backstop operating behind that. So it can be quite desirable, actually. It can be faster, it can be cheaper, it can be easier to get a deal done. Alternatively, a litigant can work together with a litigation finance firm. And this is now, again, a very, very quickly evolving area of finance. Initially, it was structured largely as venture capital. Then kind of private credit plus insurance got involved. Now there are private equity firms and hedge funds that are dipping a toe in. And again, it's very important. One of the things that allows a litigant to be successful is knowing that they've got enough powder in the bank that they can deal with large, well-funded counterparties over multiple years. And so even though this kind of funding can often be expensive, it can be priced at venture type rates, it's going to be necessary in order to deal with the situation that litigants face. So one of the things that is very important that's noted in this last bullet is that the funder, whoever it is and whatever it is a passive investor. In other words, they do not have control of the case. They do not have settlement authority. They are not in any way able to influence the outcome of the litigation. And that's becoming a bigger issue, both legally and financially. But very important to make sure that everybody is aligned and understands that it's the litigant that's ultimately going to have settlement authority and the ability to hire and fire counsel and so on. We'll talk about that on slides that follow.
Thanks. One of the metaphors that I use when I'm talking about law firms and finance entities is a horse and a jockey, where the horse is the case and the jockey is the litigation firm. And the reason that I think it's an apt metaphor is very few people who are betting on a horse race really understand the horses as well, but they understand jockeys. And that's the way I look at these litigation finance firms. They know the law firms. If a law firm thinks the case is good, that goes a long way. There's a direct correlation, in my view, between a good law firm and a successful outcome. So finding the best firm you can, I think, is really critical. One other interesting issue is that the litigation firms will vet the case with their own counsel. So you have the litigation firm who does it and the law firm for the financier. So you have multiple vettings going on before the case is filed. And in patent litigation, that's really key because there are so many potential pitfalls. And if you understand the pitfalls, you can structure the case in a certain way from the very beginning. So there really can be a huge advantage to getting litigation financing if the financier has done their due diligence. Importantly, the litigation financier is giving out a non-recourse loan. And that means that the patent owner does not have to pay it back, as opposed to just about every other type of loan where even if things don't work out, you have to pay it back. This is one where everyone goes in with their eyes open. So the quality of the case is important because if it's deemed not to be a good risk by the financier, they just won't fund it. In terms of fee arrangements, the standard is generally for a full contingency is a 60-40 deal, where the patent owner gets 60 and the litigation firm gets 40. If we're talking about a litigation finance entity, there's a myriad of different types of financing. There's milestones, there's step-ups. There's a lot of things that multiples of invested money, sometimes multiples of committed money. So the details are really important. And anyone who's going to be dealing with a litigation finance entity needs to have somebody, preferably a lawyer who understands the industry, review the agreement because it can be very, very detailed. But it covers an expense. The patent litigation can be very expensive if you're going to go for the big dollars. And as Eric said, you really want to have dry powder to use if you're going to go against a big company.
So let's talk about some of the engagement terms that you'll encounter when dealing with contingent law firms. Again, we talk about expenses and fees, or costs and fees. And expenses are really all of the out-of-pocket expenses. I mean, these are the things that are going to have to be paid to third parties. And again, it could be anything, the simple ones, experts, travel, and so on. Generally, those are going to be repaid by whoever or to whomever advanced the money first before there's any other kind of waterfall in which there is a return to capital. So if you think about the trial of a case and it costs $100 to get all the way to trial and to resolve the case, if $20 was paid to, and we'll simplify, just expert witnesses, and $80 is remaining, the $20 is going to be repaid to whoever advanced that $20 first, and then the $80 remaining is going to be divided up amongst the parties according to the way that they've negotiated their own deal. So, similarly with the fees that are paid to the law firm, again, there are all kinds of different ways that these things can be negotiated. The questions oftentimes come up as to who are the lawyers, right? Is it just the law firm that you hired? Is it IPR counsel? Is it local counsel if you're having to deal with a trial in a specific district and it is either advantageous or required to have folks who live and operate there? There are all kinds of different ways that these fee structures can be negotiated. One of the things that I kind of like conceptually, particularly when I'm dealing with contingent counsel, is a fee that goes up over time. I find that to be both economically and from kind of a strategic standpoint advantageous, to say that if we file suit and 3 days later the defendant settles the case, the counsel certainly deserves a fee. That fee, if it's 3 years later or 5 years later or 10 years later, when counsel has put in a great deal more work and time and present value, that fee ought to go up on a percentage basis. So there's all kinds of ways that you can negotiate these things, both to have a cost savings, but also to align interests where, you know, contingent counsel, they're not banks. They're law firms. And one of the things that they're really focused on is time to money. Because, you know, as Mike points out, there are fewer of these firms that are in a position that are self-capitalized, that are able to underwrite a case sufficiently to continue to operate on that kind of basis. And really what it comes down to is they've got to get in and out of a case relatively quickly as compared to a firm that is in a position to get paid full fees for 15 years worth of legal work. So having a fee structure that rewards early and aligned exit from the case can be very, very valuable.
Is this me?
Sure, go ahead.
So again, with more on the financial terms, the revenue splitting the pie is obviously of critical importance. And there are many cases where you don't file just one case, but you're filing multiple cases. So when the revenue comes in, again, this can be very complicated. And understanding what the waterfall is. The waterfall is how the proceeds are distributed. And all patent owners should make sure that they get some water, no matter what. So there are situations where the patent owner will settle for something other than money. Money is the easiest, obviously. But if there's a benefit, whether it's a cross-license to other patents, whether it's a good deal to some other of the defendant's industry, shares in stock, or some sort of purchase, then you have to figure out the fair value of that. And so you're going from complicated to very complicated in that situation. So much of this are things that you really need to figure out early in the game, hopefully in the actual agreement. If your patent is getting old and maybe you want to go after a lot of infringers, or for whatever reason you decide to go after a lot of infringers, then you have a fairly complicated scenario again, where money is going to be coming in at different times. I think it's the best to have one law firm do it all. Law firms generally don't play well in the sandbox together. So if you have multiple cases with multiple firms, you're adding almost too much complexity. So figuring out how the funder gets paid, if the funder is funding 3 or 4 cases, that's really critical. And importantly for the patent owner, what matters is understanding what he or she will receive after the money is split. There are many times where a patent owner won't necessarily appreciate that they're settling for X, assuming they're going to get a good portion of X, but they don't, because of the details in the agreement, the interest rate, all the different factors. So it's very, very important for a situation where there are multiple defendants or potential defendants to understand how the money is split. One situation that I'm involved in from time to time is where the funder will give the patent owner working capital. That's money right up front, and it could be $1, $2, $3 million or more. And in that situation, the funder wants to take the sting out of any initial disbursement. If the patent owner isn't going to get much money because there are a lot of defendants, they want to give the patent owner something up front so the patent owner won't be loath to settle at a number where he or she won't get that much money. So upfront money or working capital can be beneficial for everyone. And in all cases, just like I was saying before, it's non-recourse. So if the patent owner gets that upfront money, they don't have to give it back even if the case loses. One other aspect to this is the right to either litigate or fund future cases. Most litigation firms want to build on the value that they created. So if a litigation firm wins a case or gets a favorable settlement, they're up the learning curve, they've done very well, and they want to go into the next one. And some patent owners, want to cut a new deal with a new firm possibly. So litigation firms will often give themselves a right of first refusal for future cases. The same thing with funders. If they have had success and they made a good amount of money, they want the option of going after case 2 or 3 or 4 because they want to build on their investment. So these are all things that could certainly be in an agreement between the funder and the litigation firm and the patent owner.
Yeah, one suggestion based on hard-earned experience, at the end of a case, and there's money to divvy up, there's always going to be a spreadsheet. And the spreadsheet shows who got what, and everybody has to agree to it, and then the checks get cut. My suggestion would be ask for that spreadsheet before the case starts. When you go into a funding deal, whether it's with a law firm or a funder or both, ask for the spreadsheet up front so you can actually model out. You put in, we got $10 million, pick a number, it doesn't matter. But have the spreadsheet up front because that's what's actually going to illustrate how the money flows and where those flows are going to go. Definitely recommend that as an early tool. So let's talk about the scope of engagement. This is kind of an interesting activity. Generally, a firm will do some case analysis at no charge. So they're going to take a quick look and make sure that this at least passes the smell test for their involvement, particularly if they're going to be, if they're getting paid full freight, they get paid full freight. If they're going to be doing it on a contingent basis, they're effectively making an investment in your success. So that's going to be very, very important. It's also very important to understand and to have alignment and understanding clarity on who's involved in what. So, the law firm, again, if you've got multiple potential infringers, the law firm is handling the litigation, and maybe in-house counsel or the CEO of the patent owner is working on licensing in parallel. Who makes sure that everybody is singing out of the same hymn book? Those kinds of things are very, very important. IPRs. Nobody gets paid for winning an IPR. So, who's going to do the IPR work at $200,000 or $250,000 a pop? Who's going to pay for it? Because if your contingent counsel wins the IPR, that's great, but you don't make any money. Now, it may lead to a settlement. It may help in the negotiation for the ultimate outcome, but the IPR is oftentimes a specialist kind of activity and a non-revenue event. So just important to be aware of that. And then, of course, there are all kinds of what I would call almost peripheral things that happen where, there's a counterclaim and maybe that takes the shape of, a contractual dispute, or somebody comes back at you alleging fraud or misrepresentation or any of these other kinds of things where patent litigation counsel really is not the lawyers that you want to have dealing with that. So who's going to be doing that? And of course, again, over and over and over, counsel, particularly contingent counsel, will generally require in their engagement letter that they have the right to tell you their opinion of the matter and to suggest that you either take or reject a settlement offer. But ultimately, the settlement decision remains with the litigant. It's not something that a lawyer can do on behalf of a client. The question, of course, is if you disregard their advice, good, honest, solid, considered advice, what are their options? So we'll talk about that.
Indeed. If we could go back to the previous slide, The first bullet point is my opportunity for a shameless plug for what I do. I am a full contingency patent litigation monetization attorney. I do the EOUs, the damages analysis, and the validity, and pay for everything for my clients. And one of the reasons I do that is litigation firms are constantly working. They have deadlines, they have depositions, they have trials. And for them to look at a new matter takes away from that. And especially if they're not going to take the new matter, that's just money they're throwing out the window. So what I do is I do that analysis for the litigation firm. So rather than them having to spend 10 or 20 hours figuring out if they like a case, they only have to spend an hour or two once they read my case analysis. So that's my little plug. On top of what Aaric had said, an important point in the previous slide is our counterclaims. If you're an operating company, you could get sued for the defendant's patents asserting patent infringement against you. So understanding who's going to be your lawyer in that situation is really critical. Obviously, if you're a non-practicing entity, then you don't have an operation that can get sued. But understanding that in the engagement is really important if you're an operating company. And so if you want your litigation counsel to defend you against any potential patent counterclaims coming against you, that will shift the fee arrangement. And it might require a funder to get involved. So understanding that for operating companies, it's a different dynamic than NPEs, which is one of the reasons that NPE litigation is so prevalent, because it doesn't give the defendant the opportunity to fire up a case against them. So, in terms of exclusivity, as I'd mentioned before, when there's multiple cases, you don't want to have more than one firm. Firms, in my experience, virtually every firm looks at a case with a different point of view. When I'm talking to litigation firms about a case analysis that I did, and one firm might pass for Section 112 reasons, another one might pass because they don't think there's much damages, another one might pass because they don't like the infringement read. So it isn't a situation where the facts are plain and everyone can agree. Different lawyers have different thoughts on cases. So making sure that you have one captain of the ship is really critical. In terms of talking to litigation firms one at a time, I'm a very big proponent of doing that, of not sending out a case to multiple firms. Litigation firms, especially contingency firms, are constantly overworked. They constantly are meeting deadlines. If they like a case and you tell them that you gave it to someone else, they're simply not going to look at the next case from you. It's really that easy. So developing that relationship, understanding their point of view is really important. And also understanding who potential targets are, the potential damages, defendants, because they're going to want to clear conflicts, and maybe the first defendant won't be a problem with it, but if the second one is, they can find themselves in some hot water with their other client. So be careful on the exclusivity front.
Yeah, I think that's a really important point, and I want to drive home what Mike said about building and maintaining relationships. No matter how careful you are, no matter how many transactions lawyers you hire, no agreement that you sign, whether it's with a funder or with a law firm, is going to cover every eventuality. It's impossible. You'll never get a case on file. And so being in a position to have built the relationship capital over time, where that relationship capital fills the gap when there's an issue in the engagement that either isn't addressed or is addressed, but is addressed in such a way that it doesn't work in a meaningful way for one or both parties, that's just really, really important. And so I think that the more work that you can do, when you find a good jockey, bet that jockey all day long, all day long. I used to be in the horse racing business. I know that. Bet that jockey all day long. And it really does make a difference. It pays off in spades because there's always going to be a gap. And you don't want to have that gap go against you because you tried to do something that was short-term smart. So, again, this kind of gets to the same point. When you're talking about staffing, you hire the XYZ law firm, but who at the XYZ law firm is actually going to be doing the case? And so how much of the work is going to be done by the person that you engaged with and that you wanted to hire? If you're talking about, a boutique firm, how boutique are they? And what do they do when you go up against, one of the behemoths that walks into trial with 50 of their best personal friends serving as defense counsel? These are the kinds of things that you really do need to be thinking about. It's an interesting question, this high stakes matters. I talked with a litigator the other day who gave me a very interesting insight. He says, the funny thing about my business is the way that I market my firm is by publicizing on my website that I got big jury verdicts against big clients, against big defendants. And that's what you have to do in order to build a name. But the way that you really make money generally is by settling a case earlier at maybe a dime on the dollar, 30 cents on the dollar, whatever it is. But he said it's a very interesting tension between my desire to get famous and my desire to make my client rich. And so these are the kinds of things that have to be thought through. What is the internal strategy? How is your law firm thinking about who they're going to put on a case, how many people they're going to put on a case, their ability to flex up and down, because you don't want to have every associate at a firm billing 2,000 hours a month just to keep everybody on the payroll. Those are the kinds of things that you got to be very, very careful about and really manage. Frankly, have some insight and some help in managing those kinds of things. Mike, you were in big firms. You know these issues very, very well, no doubt.
Indeed, I do. One of the things I wanted to build on was what Aaric had said about relationships and the different lawyers. So there is the possibility that a patent litigation can involve 3 different law firms: local counsel, lead counsel, and IPR counsel. In those situations, coordination is very, very difficult. In my experience, when I was a lead litigator, it frustrated me when my client would decide who my local counsel was, because I kind of felt like there was a spy there. It wasn't a relationship that I had with the lawyer. It was the lawyer reporting back to the client. And maybe the client wanted that, but I didn't like it. And it created a situation where I really couldn't be completely open and honest about strategy because I didn't want there to be discussion behind my back. So because of that, in my practice, what I do is I have the lead lawyer choose who he wants to be local counsel and who she wants to be IPR counsel if there was going to be a separate IPR counsel. That way, there's a relationship between them. I look at them as one team, and there's no one talking behind anyone's back. So I think that's really important. And it's human nature. A lot of this is just human nature. As Aaric said, relationships are important, and making sure that people feel comfortable because they'll do their best work when they're comfortable.
Mike, you want to speak to termination and withdrawal?
Sounds good. So the key word I have here is balance. Termination is when the client has decided that he wants to go hire a different firm. So he's going to terminate the firm that has already engaged. And withdrawal is where the law firm decides that they want out. And they're both very, very delicate situations. I've been involved in both of them on all different sides. And as Aaric said, if you're going to try to figure out an agreement that has every possible scenario, it's going to be 1,000 pages, and no one wants that. So there's a good faith here. There's a balance here. There are certain terms like for cause. If you want to terminate your counsel for cause, it's a very specific legal term. They must have done something bad. Or without cause. You've decided you think someone else can do a better job, but there really isn't anything bad that they did. So those terms creep up throughout it, throughout an agreement, and you should expect to see them because there's a big difference. For a litigation firm, we're doing a great job. We understand your best friend is in another firm and you want to use him, but we should still get compensated for our work. There are clients, believe it or not, that will terminate their lawyers just before the money's coming in. It's obviously very bad faith. And a litigation firm will fight that, of course, and make sure that it's in the agreement that you can't do that. Again, getting back to the relationship part of this, at the beginning of a case, if you see red flags, if you just don't like the lawyer, even though he's come highly recommended, he's won a bunch of cases, if you just don't like the attitude or something is off, do not get engaged with them, because a litigation is like a roller coaster. You have your ups and your downs, and in virtually every case, even cases where we've either won or settled for 8 figures, there are times where you wonder how you're going to get out of this. You don't see a way forward. So you really need someone who you can count on, who's honest, who's straightforward. And so understanding all of that. For withdrawal, a lawyer is an officer of the court. So he can't just quit a case. He has to get permission from the court. If the client agrees, the court will generally allow it to happen because both parties agree. But if the client doesn't want them to withdraw, there is a chance that the judge will keep them in. So if you're a litigation firm, you want to have an upfront agreement from the client about withdrawal, and making sure that if you decide the case isn't worth it, that you're throwing good money after bad, or if you know of a reason why you think you're going to lose and the client just won't listen to reality, you want to be able to get out. Or as Aaric said before, if there's a really reasonable settlement offer, but the client isn't reasonable, you might decide this is not the fight we want to spend our time on. So it's uncomfortable for everyone to talk about termination and withdrawal before the case is brought, because that's the time where everyone's happy and celebrating and we're going to win and we have the greatest patent in the world. But these things need to be addressed. They need to be considered. And in general, if you're a patent owner, you should have someone else look at this with you so you understand what's happening, because a litigation firm's going to want to tip the balance in their direction, because they're going to be putting so much time and money and effort into it. So balance is the most important thing to me. Both sides should understand what's going on and have a good faith belief on how things will result.
Yeah, I think that's exactly right. I mean, to me, this is the prenuptial agreement that you sign with your lawyer. And I think Mike hit on the right point, which is, if you had a friend who said, I'm not so sure about this woman that I'm fixing to marry, but, not to worry, I've got a prenup agreement. If that's what you're banking on, you got a real problem. So you got to have these provisions in place, and you pray you never have to use them, because to say it's painful and difficult and frankly a distraction from the underlying case is an understatement.
Can I ask a question along these lines?
Sure.
How does one find a good contingency law firm or litigation funder? You just have to kind of work your network, or can you go to something like Docket Navigator and do searches and see which law firms got the biggest verdicts, depending on classifications of patents or something like that?
It's really easy. You hire me and Mike. It's the simple answer. No, I'll take the first answer and then let Mike give the real one. But I think the reality is you work your network. I mean, obviously there are some statistics, but again, you know, I could argue and make a very credible argument that the best lawyer, the best litigator, is one who's never won a trial, because every single one of them has settled pre-trial for a nice number, right? So I think there's all kinds of things that go into that analysis, and I think the best thing is to work your network and to talk to people and say, you know, with whom have you had a good working relationship and who has made you a bunch of money? Those are,
Okay.
and I would suggest that those are equally important.
Yeah, I agree. When you're looking for a doctor, do you go online and just find a doctor, or do you talk to your friends and see, you know, if they've had a similar issue and who they went to? It's the same type of thing where, and again, you could talk to lawyers. I would recommend talking to a lawyer, even if he isn't a patent lawyer, even if he isn't a contingency lawyer. Lawyers will know, and you know, I've been doing this for almost 40 years. So I certainly have a sense of the different people in the different firms. You know, the same thing with funders, understanding the funding world. You can, you know, go on a search, Google or wherever, and type in litigation funders, and you'll get a bunch of ads for people who are in the industry. And that could work out great for you, but chances are very good it's going to be a waste of time. So knowing someone in the field is really the key.
Okay, great. We have some more questions. So if you want to finish up your presentation, we can go into questions. Thank you.
Yeah, I think I'm going to hit this one quickly just to say that, you know, litigation funding or litigation has become an asset class. And whenever something becomes an asset class, there's all kinds of money. And the traditional venture model litigation funders, the Burfords and the Longfords and the Omnis, are now being complemented by hedge funds and family offices, crowdfunding, debt and insurance, all kinds of things. And you know, it's like saying, well, I need a loan. Do I go to, you know, one of the big Wall Street banks, or do I go for an SBA loan? Right? This is not something that you do on an amateur basis, because even sophisticated people will be led in the wrong direction and find things that are ill-suited for their specific needs, and they'll waste a bunch of time and a bunch of effort. 95% of cases don't get funded, not because the cases are bad, but because you bring it to the wrong guy. So, you know, working with somebody that can really help you navigate the process really is important.
Yeah, I'll add on to that. If you could go back to the slide. Virtually all of my cases that are funded by hedge funds. And unlike the litigation funders who you can just Google, hedge funds, you have to know somebody. There has to be an in. And that money is serious money, and they've done a good job for me. The last bullet point here is the pretenders. Just a quick story. I met with someone who told me he would never run out of money, which is a pretty aggressive statement. And it turned out he had no money. He was trying to, you know, he would run to the hedge fund or someone else and try to ask for it. So he wasn't going to run out of money because he didn't have any money. And then the last thing is there are two advisors out there that I think are also very good, Tenadio and Westfleet. Obviously, in addition to Aaric's shop, they don't have money. They don't pretend to have money, but they're pretty good guides out there. So I would just want to give them a shout out because I think they're both very good.
So go ahead, Mike.
I was going to say, if David, if you want to turn to questions, you know, there are a couple of other slides we have here, but if you think questions are the better way to go, we're happy to do that.
Yeah, this seems pretty interesting too. You know, if you want to go through these pretty quickly, We'll do that.
Okay. I'll run through it just quickly, which is to say, the first point is the most important one. There are no standard terms, with the one caveat being the last one, which is only the patentee has the right to settle. I'm not a lawyer, Michael, correct me, but I believe that's a legal issue in American courts. But the reality is that everything else can be negotiated, and the important thing is to realize it's like buying a car. I buy a car every 10 years. The guy on the lot sells one every third day. Who's going to be better at it? And it's the same kind of thing with litigation funding. If unless you are consistently in the market, knowing what the terms are from various types of funders, how those terms change over time, sequencing, which funder do you go to first because they have requirements that actually preclude you going to subsequent funders, just because of the way that the deals are structured and what they're looking for. All of those kinds of things can get very, very, very complex. And again, whether you work with me, Mike, or the Westfleet guys, work with somebody, because this is not something that you will do your first time the way you want to do it your 10th time. The standard things that you need to be aware of are you're looking at a business investment, and that's very much, the thing that gets reflected in these terms are very few legal issues, and they're really more investment issues. And so when you've got your patent lawyer helping you to the extent that they do, which is questionable, but a patent lawyer is a good patent lawyer doesn't necessarily mean they're a good fund or an investment analyst. And that's really what you're talking about here. The funders are looking at these things on a net present value basis, on an internal rate of return basis. They've got a very different calculus, a very different vocabulary than most lawyers and law firms. And so if you're working exclusively with somebody who is versed in litigation, you're going to end up talking past each other. And you really want to make sure that you've got somebody that understands not just the operational aspects of your funding agreement, but the way that those financial terms are going to play out, and can model something that tells you whether or not you've got a good deal or not. Because, some deals that look great under one set of assumptions, if it goes out 5 years or 10 years or 15 years, all of a sudden, if you structured it with an interest rate, you don't get any money. So, these are the kinds of things that experience teaches.
Yeah, and I'll add to that. The litigation budget is something of an oxymoron. It's impossible to know what's going to happen. You can take your best guess, and lawyers do. I've been in situations where the litigation firms come out with an outrageously high budget, and the funder just won't do it. They won't see the value there. And I've been in situations where the litigation firm decided to shoot low so they get the case funded, and they wind up losing a ton of money because they didn't budget it correctly. So it's a very difficult situation, but you want to really try to hit that sweet spot when you budget.
Yeah, and getting it wrong can be disastrous. I've run into situations before where the first money was priced pretty, well, and counsel forgot to put in money for appeals. And when we went back to the funder asking for more money for the appeals, let's just say that the price had gone up. So, those are the kinds of things that change the calculus. And it's got to be reworked in a rational way.
And then finally, just quickly here, as with the termination of counsel and withdrawal by counsel, a lot of these terms are a little uncomfortable, but arbitration is, I find, to be a great way to go if there's a dispute. It's low key, it's a lot less expensive. As both Aaric and I had said several times, it's important that the proper party be the plaintiff. If the investor has too much control, the investor has to be the plaintiff. Right now, only one judge, Judge Connolly in Delaware, requires that the parties list who's investing and who has an interest there. I think it's interesting that the other judges in Delaware have not joined him with this. No judge anywhere has joined him with this. So I think it's unlikely that it's going to become the rule of the land. There was a case against IP Edge where Judge Connolly really took it pretty hard to them. And I think that scared away a lot of people who would want to have control but not be the plaintiff in the case. But making sure that it's all spelled out, because your agreement might be in front of a judge someday and you want the judge to be able to see a clause that says the investor does not have control over settlement, only the patent owner plaintiff does.
Should we pause here for questions?
Yeah, I think so. This is great. So a few quick questions. What is the stance of contingency lawyers and litigation funders on lost profit pursuits? Usually it's more lucrative if you're eligible to pursue lost profits, but maybe it's harder and takes more time.
Well, lost profits means that there's an operating company, that the operating company makes the product and would have sold more but for the infringement. And so, as I had said before, an operating company filing a patent litigation introduces certain aspects that a contingency firm and or a funder might be a little concerned with. For example, the counterclaims from the defendant for patent infringement. So lost profits, unless the company's gone bankrupt and is no longer making product, lost profits would be for an operating company, and that would certainly introduce risks. In general, it's a reasonable royalty.
Okay. And then earlier today, another speaker was telling us that in Europe, essentially, there's no contingency litigation as far as patents go. If part of the assertion strategy is to assert in Europe, are American contingency lawyers limited in their pursuit of damages in Europe?
Well, there are certainly several statutes that allow an American patent plaintiff to reach outside the U.S. For damages. But in Europe, even though there's no contingency lawyers, there's plenty of funders. So you can get a funder to pay for the law firm and operate on multiple continents that way.
Okay. And so did I understand you right that only Judge Connolly has demanded disclosure of investor interest? That's the point? Okay. Maybe why is there a discussion? Why is there some interest? We hear about it more, but why is there some interest in requiring the plaintiff to disclose who is funding the litigation? And even with Judge Connolly, did Judge Connolly demand to review the contingency agreement, or just wanted to know about the existence of it?
Well, Aaric, you go first.
I'm going to tell the straw man version of the argument. The straw man version of the argument is that North Korea is funding all of the patent litigation in the United States and is using that as a secret way to learn all about our technology and to bankrupt all of our wonderful American innovative companies. That's what you'll read on the op-ed page. As I say, it's a straw man, to say the least. The reality is that much of the discussion around disclosure is 100% strategic. If I know that the guy on the other side of the table has a budget, and it's one of the things that Mike alluded to, maybe there's a milestone payment, okay? And so if I know that the guy on the other side of the table only has enough cash to get to, whatever stage of the litigation, and all I have to do is hold out for another 6 weeks, 6 months, or whatever the time period is, I know I'm going to win the case. And so what the other side is looking for in this disclosure issue is a tactical or strategic advantage by knowing what the other side is able to spend. And I find the argument to be disingenuous in the extreme. If a judge wants to know, and kind of answer the binary question, is the litigant truly the litigant? I have absolutely no objection to that. I also have no objection as a litigant saying, guess what, guys? I've got a bunch of money because I'm being backed by the XYZ litigation funder. I'm good with that. What I don't want is to have somebody use my litigation funding agreement against me as a roadmap to litigation strategy. That's what I think is unfair, because generally on the other side of the table, you're dealing with public companies who have access via the public capital markets to effectively unlimited amounts of money. And so really it's just a question of knowing how long can the other guy hold out. I'll tell one quick anecdote and then let Mike weigh in. I have a friend who was the CEO of a public company, a microcap, small public company, and he's got to make SEC filings. And those SEC filings say exactly how much cash he has on his balance sheet. And he used to routinely get calls from the other side that say, hey, I know where you are. I know how much you've got. And why don't we settle today rather than you continuing to fight, this good fight, because it's going to bankrupt your company. That's the reality.
Yeah.
I'll just add to that the law is very clear that all of the parties in a case need to be present. So if there are multiple people who own the patent, those multiple people all have to be in the case. What the law doesn't want to do is go in a piecemeal fashion where owner A has a shot and then owner B says, well, I didn't get my shot. So everyone involved, all the people involved in the plaintiff have to be present. Usually we just have one company that owns the patent. But if an investor has some control, that investor is a plaintiff because that investor is operating as a party. And so in theory, what Judge Connolly is doing, can make some sense. But the reality is everyone knows this rule, and no litigation funders ever going to cross that line because they don't want to be a plaintiff and be subject to discovery. So I'm glad that it hasn't gone far, because I think it's a silly proposition.
Even if it was to go beyond Judge Connolly, could the agreement be presented to a jury? Would the jury be privy to such an agreement?
I believe that would be inadmissible, and it wouldn't really go towards any issue that the jury would be involved in.
Okay, good. Just a couple other questions. What is the stance on litigation funders with fee shifting? So if the defendant wins and use Octane Fitness and try to charge the plaintiff for the defendant's fees, what did the agreement say?
Well, it depends on what the agreement says. When I'm representing my client, I want there to be a clause that says the client will not pay $1 no matter what happens in the case. That's often negotiated, and litigation funders can push back on that. But yeah, that should be a term that should be considered in the agreement between the lawyer and the patent owner and the patent owner and the funder.
Mm-hmm. How would you, as a contingency lawyer or litigation funder, be compensated if the defendant was acquired by the plaintiff?
Yeah, that's a good that's a good question. again, it's one of those things that gets a little bit tricky. Mike mentioned that sometimes there's non-monetary or non-cash compensation to resolve a lawsuit, and this would be an example of that. I think if the plaintiff were acquired by the defendant, there would need to be some allocation of the total purchase price to the resolution of this lawsuit, and reasonable people could disagree as to what that is, and that's why you have arbitration. But there would have to be at least a good faith allocation to say, the company was purchased for $100 million, $5 million of which could be reasonably attributed to the resolution of this suit, and that's the that's the damages that would flow through the waterfall to the lit funder, to the lawyers, and so on.
And if you're a contingency fee lawyer or an investor, you're going to consider this and see if the patent owner would be reasonable and communicate with you this possibility long before any deal is done. And it goes back to relationships, understanding people, trusting people, and only dealing with honest, direct people.
Mm-hmm. Where are interest rates now on capital committed by litigation funders? What kind of interest rates do they charge?
In litigation, I'm seeing mid-teens, 20%, thereabouts. It depends. Again, the favorite word of these guys is bespoke, which just means it depends. So it depends on whether or not there's insurance in place. It depends on whether or not they're making a naked loan. But I think you ought to be, as you're modeling things, if somebody comes back and says, we're going to loan you money against an insurance policy at 15 to 20%, that's not crazy.
Okay.
And that's, sometimes the insurance covers only the lender's principal. Sometimes it covers the principal plus some or all of their return. That's getting a little bit more tricky because nobody likes to have a participant in a deal that has no risk. And so if as a lender, I no longer have to underwrite the case, all I have to underwrite is the insurance because I'm guaranteed return of principal plus my interest factor, that gets a little tough.
Okay. In a previous session, Mike made a very good point about budgeting. If you're a key lawyer working on the deal as a mid-level associate, when you budget that out, fees are going to go up because of inflation and also because he'll be a partner in several years and fees go up there. So I thought that was an interesting point that Mike made in a previous session. Okay, well, great. This was really informative. We very much appreciate your speaking to us. We all learned a lot from you. And we know where to go if we need contingency lawyers or litigation funders. So thank you so much.
Thank you.
Can we make your presentation available to people?
Of course.
Please.
Okay, perfect. Thank you so much. Okay. All right.